This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about why, when someone tries to sue an insurance company for breach of contract, it is necessary to first have evidence establishing that the contract was breached, and why an appraisal award simply sets the amount of damages to be recovered from an insurer and will be upheld almost invariably, and why, therefore, it is a waste of time to sue your insurer if you don't have the evidence. In a case entitled Beaty and Jonathan Hayes versus Homeowners of America Insurance Company, the Court of Appeals of Texas on August 26, 2025, dealt with the claim of the Hayes under their homeowners insurance policy with Homeowners of America Insurance Company after a windstorm allegedly damaged their home in April of 2020. The insurer paid for some repairs but denied further coverage, leading Beaty and Hayes to sue for breach of contract and other claims. Their claim was for roof damage caused by a windstorm. An appraisal award was eventually issued, valuing the total loss at $30,681.81, with $15,508.35 attributed to roof-related repairs. The insurer paid the appraisal award less the deductible and less prior payments. The insurer conclusively negated the breach element required to be proved to prove a breach of contract cause of action, because Beaty and Hayes did not produce evidence raising a genuine issue of material fact. Beaty and Hayes did not raise a fact issue on whether they were entitled to additional benefits under the policy in excess of the breach of contract. The trial court therefore granted summary judgment in favor of the insurer, concluding the insurer did not breach the policy and that Beaty and Hayes were not entitled to additional benefits. Unhappy, Beaty and Hayes filed suit against the insurer in May of 2022. They asked the trial court to vacate the appraisal award on the grounds that it was made pursuant to the insurer's fraudulent conduct. It was the product of a gross mistake, and it exceeded the appraisal panel's scope of authority under the policy. The insurer moved for summary judgment, and the trial court signed a final judgment granting the insurer's summary judgment motion and ordering that Beaty and Hayes take nothing on their claims. An appraisal provides an extrajudicial remedy for disagreements about the amount of loss. From a policy point of view, appraisal clauses allow the insured and the insurer to resolve disputes about damages with greater efficiency by eliminating the cost and delay of traditional litigation. Courts will indulge every reasonable presumption to sustain an appraisal award. To avoid enforcement of an appraisal award, a party must establish one of three grounds for setting aside the award. 1, the award was made without authority. 2, it was made as a result of fraud, accident, or mistake. Or 3, it did not comply with the requirements of the policy. All 3 were not available and were not proved by Beaty and Hayes. The award set the actual cash value of the loss at $30,681.81, of which amount an attached estimate attributed $15,508.35, to roof-related repairs. The Court of Appeals, therefore, concluded that the failure to prove any of the elements of breach of contract required a finding in favor of the insurer. An insured cannot recover for an insurer's violation of its common law and statutory duties unless the insured establishes either that she has a right to benefits under the policy or that the insurer committed an act so extreme as to cause injury independent of a right to benefits. Beaty and Hayes did not produce a scintilla of evidence, that's even less than the value of a peppercorn, that the policy provided them a right to additional benefits, and therefore the Court of Appeal concluded the trial court did not err by granting summary judgment. In my opinion, some people who present insurance claims think that an insurer will do no investigation and simply pay them whatever they ask. Beaty and Hayes believed that, and when they didn't get what they wanted, even after an appraisal panel set the amount of loss and the insurer paid the award, they still wanted more and sued, only to find that the Court of Appeals concluded that they failed to even prove a tiny bit of evidence that they were entitled to more benefits. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you will gain access to the more than 5,150 blog postings. Please tell your friends and colleagues about this blog and videos, and let them subscribe as well. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.